Hello guys and welcome to Bharatwaj classes. In the last class, the video ended abruptly because my system shut down abruptly, so I had to end it. Although I didn't wanted to end it there. But I hope you must have understood the basic concepts of the fundamental rights and all the introduction and all parts. Today we are going to discuss the fundamental rights, and there are six fundamental rights mentioned in part 3. Earlier there were seven fundamental rights, but Article 31, that is right to property, has been removed from the list of fundamental rights, and now there are only six fundamental rights that are left with us. So fundamental rights: first, right to equality; second, right to freedom; third, right against exploitation; right to religion; fifth, cultural and educational right; sixth, earlier right to property was your sixth fundamental right, but now it has been removed from the list of fundamental rights and has been made as constitutional legal right under Article 300A through 44th Amendment Act 1978. Now, sixth fundamental right is your right to constitutional remedy. Right to constitutional remedy. Now, let us see the article which deals with these rights. Right to equality, Article 14 to 18. 14 to 18. Right to freedom, 19 to 22. Right against exploitation, 23 and 24. Right to religion, 25 and 28. Cultural and educational right, 29 and 30. And this right to constitutional remedy, 32 and 226. So let's start with the right to equality. Right to equality. Right to right to equality. Article 14 to 18. In this segment, in all our fundamental rights, we will be dealing each article in detail, and sometimes we will be dealing with the sub clauses also, because in many times the question is directly or indirectly based on the articles, and if you know the articles or if you have basic awareness about this article, you can directly answer. So let's start. Article 14. Article 14. Article 14. I will be writing articles, so it's better you should also note it down in your rough copy or anywhere else. It will be a kind of revision for you. तो आर्टिकल 14 क्या बोलता है? आर्टिकल 14 बोलता है कि it states that state shall not deny to any individual. जो state है वो किसी को भी deny ना करे. State shall not deny to any individual, किसी भी individual को, any individual means this right is available to both citizens as well as foreigner. Any individual. Article 14 says that state shall not deny to any individual the right to, दो चीजें डिनाई नहीं करनी है. कौन कौन सी? एक तो इक्वेलिटी बिफोर लॉ, और दूसरी जो है इक्वल प्रोटेक्शन ऑफ लॉ. इक्वल प्रोटेक्शन ऑफ लॉ. अब इनका मतलब क्या है आपको मैं समझाता हूँ। तो आर्टिकल 14 को ध्यान से देखिए। आर्टिकल 14 क्या बोल रहा है कि आर्टिकल 14 बोलता है कि स्टेट जो है, स्टेट स्टेट को क्या नहीं करना, स्टेट शैल नॉट डिनाई टू एनी इंडिविजुअल द टू थिंग्स, दैट इज इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ। तो इक्वालिटी बिफोर लॉ क्या है? इक्वालिटी बिफोर लॉ, लेट अस अंडरस्टैंड द कॉन्सेप्ट ऑफ इक्वालिटी बिफोर लॉ। इक्वालिटी बिफोर लॉ, दिस कॉन्सेप्ट originated in England, originated in England and is a negatively worded concept। negatively worded concept, negatively worded concept का मतलब क्या है? इसका मतलब ये है कि absence of privileges, absence of privileges, absence of privileges, privileges enjoyed by a particular person in the eyes of law, in the eyes of law। मतलब ये है कि कानून की नजर में चाहे वो कोई भी हो, whether he is a president or whether a common man, both are equal। तो equality before law, it is a concept which originated from England or the UK and is a negatively worded concept which means absence of privileges enjoyed by a particular person in the eyes of law। इसका मतलब क्या है कि all persons, all person, all person, जो भी persons है, all person irrespective of their rank or position shall be treated equally by law, equally by law and are equal before the law। ठीक है, and are equal before the law। तो इक्वलिटी बिफोर लॉ जो बोलता है कि जो भी पर्सन है, ऑल द पर्सन्स इरेस्पेक्टिव ऑफ देयर रैंक और पोजीशन, चाहे कोई भी रैंक हो चाहे कोई भी पोजीशन हो, आर इक्वल बाय द लॉ एंड शैल बी ट्रीटेड इक्वली बाय द लॉ एंड आर इक्वल बिफोर द लॉ। कानून की नजर में बराबर है और बराबर वाला ही उनको पनिशमेंट मिलेगा अगर वो कोई क्राइम करते हैं तो। ठीक है, तो इस क्लॉज को देख के और इस इक्वलिटी बिफोर लॉ को देख के आपको लगा होगा क्या कि इक्वलिटी बिफोर लॉ प्रोवाइड्स फॉर व्हाट? इट प्रोवाइड्स फॉर jurisdictory equality, it provides for jurisdictory equality, it provides for jurisdictory equality, jurisdictory equality and not complete equality। okay, jurisdictory equality, jurisdictory equality। okay, hope you must have got equality before law। ठीक है, तो क्या बोला इक्वलिटी बिफोर लॉ? पहले तो आर्टिकल 14 को एक बार ध्यान से देखिए। आर्टिकल 14 बोल रहा है कि स्टेट जो है, स्टेट को डिनाई नहीं करना है, शैल नॉट डिनाई एनी इंडिविजुअल द राइट टू इक्वलिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ। अब इक्वलिटी बिफोर लॉ है क्या? इक्वलिटी बिफोर लॉ, फर्स्ट ऑफ ऑल इट ओरिजिनेटेड इन इंग्लैंड एंड इट इज अ नेगेटिवली वर्डेड कॉन्सेप्ट। नेगेटिवली वर्डेड कॉन्सेप्ट का मतलब कि एब्सेंस ऑफ प्रिविलेजेस, मतलब सब लोग चाहे वो कोई भी हो, वेदर ही इज अ president, prime minister or a common man like a rickshaw puller, all persons are, all person irrespective of the rank, position or privileges are equal before the law and shall be treated equally by the law। इसका मतलब क्या है कि equal before law, equal before the law and shall be treated equally by the law, it means jurisdictory equality। Thus article 14 provides for jurisdictory equality। okay, here it is providing equality before law, is providing jurisdictory equality। now what do we mean by equal protection of law? equal protection of law क्या बोलता है? पहला कि equal protection of law, it is a positively worded concept, it is a positively worded concept। ठीक है, पॉजिटिवली वर्डेड कॉन्सेप्ट है, कहां से लिया गया भाई? अमेरिका से, वेयर इट borrowed फ्रॉम अमेरिका। ठीक है, यहाँ का मतलब क्या है? लाइक शुड बी ट्रीटेड अलाइक, लाइक को अलाइक की तरह ट्रीट करो, लाइक शुड बी ट्रीटेड अलाइक। अब इसका मतलब क्या? इट मीन्स what it means, it does not mean uniform application of law, it does not mean uniform application of law, uniform application of law under all circumstances, under all circumstances, under all circumstances। ठीक है, all circumstances, under all circumstances. So, equal protection of law is a positive concept taken from America, which means like should be treated alike, and it does not mean uniform application of law under all circumstances. But before applying the law, take the situational variation also. Take the situational variation also. ठीक है? It means, what does it mean? It means equality of treatment. It means equality of treatment, equality of treatment in equal circumstances, equal circumstances. Okay, so it give rise to positive discrimination or protective discrimination. It give rise to protective discrimination or positive discrimination under which reservation policy is justified. Reservation policy is justified. Reservation policy is justified under equal protection of law, because the concept of equal protection of law says that first of all you need to make these people who are lagging behind the normal people in par or in equal with the normal people, in equal with and then apply the same law. First, what you need to do is that you make these people reach here by giving reservation, and then let's apply the same law. So it gives rise to positive discrimination or protective discrimination under which the reservation policy is justified. Now let us discuss one more concept, rule of law. Rule rule of rule of law rule of law. This concept also came from England, and is given by A.V. Dicey. And what does rule of law means is that it means that law is supreme, मतलब कि कानून की चलेगी और कानून से बड़ा कोई नहीं है. Law is supreme. Law is supreme and absolute supremacy of law as against the arbitrary power. ठीक है, सिर्फ कानून की चलेगी, ना लेजिस्लेचर की चलेगी, ना एग्जीक्यूटिव की चलेगी तो किसकी चलेगी? सिर्फ और सिर्फ लॉ की चलेगी. ठीक है, law is supreme and absolute supremacy of law. Okay, rule of law has three principles. Rule of law के तीन principles हैं. कौन कौन से हैं? Let's see them. Rule of law has three principles. The first two principles are actually copied from the Britain, and third is a modification of our own. So let's see this concept or this principle first. It says that no man shall be punished. No man किसी भी आदमी को, no man shall be punished or made to suffer except for violation of law, and such violation should have been established in an ordinary court of law, in an ordinary court of law. In an ordinary court of law. In an ordinary court of law. Okay. तो क्या बोल रहा है पहला प्रिंसिपल कि नो मैन शैल बी पनिश्ड or made to suffer except for the violation of law and such violation should have been established or proved in an ordinary court of law। ऐसा नहीं है कि प्रेसिडेंट के लिए अलग कोर्ट बन रहा है और आपके लिए कोई अलग कोर्ट बन रहा है। यू हैव टू बी ट्रायल इन द सेम कोर्ट वेदर यू आर अ प्रेसिडेंट और अ नॉर्मल मैन। ठीक है। दूसरा, all persons all persons all persons all persons are subject to ordinary law of land, ordinary law of land, ordinary law of land without any distinction, ordinary law of land, ordinary law of land। ठीक है। दूसरा प्रिंसिपल ये है। और तीसरा ये बोलता है कि जो भी कानून पास होंगे, all the laws which are passed by the legislature, the laws all the laws which are passed by the legislature, passed by legislature, जो भी कानून लेजिस्लेचर पास करेगा, that shall be that shall be that shall line in or in accordance with the provisions of the constitution, provisions of the constitution। जो भी कानून आएंगे वो constitutions के provisions, they must be in line with the provisions of the constitution and must not be against the provisions of the constitution। ठीक है। तो रूल ऑफ लॉ, ठीक है, रूल ऑफ लॉ क्या बोलता है कि नो मैन शैल बी पनिश्ड एक्सेप्ट फॉर द वायलेशन ऑफ लॉ, ऑल पर्सन्स, ये रहा रूल ऑफ लॉ आ गया आपका। रूल ऑफ लॉ टेकन फ्रॉम इंग्लैंड एंड एवी डाइसी गेव हिम as per law, rule of law, law is supreme and it means no man shall be punished except for the violation of law and such violations should have been established in an ordinary court of law। कोई स्पेशल कोर्ट नहीं बनाया जाएगा आपके वायलेशन को और आपको कन्विक्ट करने के लिए। ऑल पर्सन्स आर सब्जेक्ट टू ऑर्डिनरी लॉ ऑफ लैंड विदाउट एनी डिस्टिंक्शंस, दैट इज absence of privileges। Third, all the laws passed by the legislature must be inconsistent with the provisions of that constitution। Okay, now let us move through our next article, article 15, article 15, article 15 सब क्लोज 1। आर्टिकल 15 सब क्लोज 1 बोलता है कि व्हाट इट डज इट से दैट स्टेट शैल नॉट डिस्क्रिमिनेट, जो स्टेट होगा स्टेट शैल नॉट डिस्क्रिमिनेट अगेंस्ट सिटीजन्स ओनली ऑन द ग्राउंड्स ऑफ, किन ग्राउंड्स पे डिस्क्रिमिनेट नहीं करना है स्टेट को, ओनली ऑन द ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ, प्लेस ऑफ बर्थ। इन बेसिस पे स्टेट कैन नॉट डिस्क्रिमिनेट अगेंस्ट सिटीजन्स ओनली ऑन द ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ। ठीक है। आर्टिकल 15 सब क्लोज 2, आर्टिकल 15 सब क्लोज 2 prohibits the state and private individual both from discriminating against citizens, from discriminating against citizens on the grounds of these grounds, on the grounds of religion, race, caste, sex, place of birth in having access to public places, in having access to public places, जैसे कि such as roads, parks, hotels or tanks, ghats, this all things which are maintained by the state, maintained by state fund। ठीक है, maintained by state fund। So what does article 30 article 15 subclause 2 say? Is it says that state and private individual both shall not discriminate against citizens on 5 grounds। कौन कौन से? religion, race, caste, sex, place of birth, in having access to public places such as roads, parks, hotels or tanks, ghats, which are maintained by the state and or the state fund। Okay, now so you read that Article 15 and Article 15 subclause 2 is trying to restrict the state from discriminating against citizens. Now, exceptions to Article 15, Article 15 subclause 3. As per Article 15 subclause 3, state can make special provision. जो state है, state can make special provision, special provision, special provision for the welfare of women, women and children, women and children, women and children. You must have seen scholarship. For example, example के ले लो, women are getting scholarships in education. Many places registration fees is waived. Registration fee is waived for the women. So Article 15 subclause 3 is an exception to Article 15, which says that state can make special provision for the advancement or for the benefit of women and children. Okay. Now Article 15 subclause 4. Article 15 subclause 4. Initially, Article 15 subclause 4 was not in our constitution, and it got added in the constitution through First Amendment Act. First Amendment Act 1951. And what does it says? That state can make special provision. Article 15 subclause 4 empowers the state to make special provision for the advancement of socially and educationally backward classes of citizens, SEBC or SCs and STs. Okay. So Article 15 subclause 4 was originally not present in the constitution, and it got added through First Amendment Act 1951, which says that state can make special provision for the advancement. किस लिए बना सकता है? For advancement of socially and educationally backward classes of citizens, or SCs and STs. Okay. Now Article 15 subclause 5. Article 15 subclause 5. What does it says? It says, like Article 15 subclause 4, Article 15 subclause 5 was also not initially present in the constitution, and it got added in the constitution through 93rd Amendment Act 2005. And it says that it empowers the state to make special provision for admission. किसके लिए? For admission of backward classes of citizens. For admission of backward classes of citizens in educational institutions, whether they are aided or unaided, except minority educational institutions. Minority educational institutions. Okay. So Article 15 subclause 5 says that state can make special provision for the admission of backward classes of citizens in educational institutions, including private educational institutions, whether they are aided or unaided, except minority educational institution. So got it? Now let us move to next Article 16. Article 16 subclause. Article 16 subclause 1. Article 16 subclause 1 क्या बोलता है कि Article 16 subclause 1 provides for equality of opportunity, opportunity, equality of opportunity to all citizens, in gaining public employment, in gaining public employment, in gaining public employment. Okay, in gaining public employment. In gaining public employment. Article 16 subclause 2 we have discussed earlier also. Article 16 subclause 1 क्या बोलता है कि it prohibits the state from discriminating citizens को discrimination से बचाएगा only on the grounds of, किन किन grounds पे, religion, race, caste, sex, place of birth, plus two more grounds, residence and descent. डिसेंट मतलब वंशज. ओके, वंश के आधार पे भी भेदभाव नहीं करेगा. इन गेनिंग पब्लिक एम्प्लॉयमेंट, ठीक है, इन गेनिंग पब्लिक एम्प्लॉयमेंट. लेट मी स्क्रॉल इट डाउन. In gaining public employment. Now, exceptions to Article 16. Article 16 subclause 3. Article 16 subclause 3 is an exception which says that Parliament is empowered. Parliament के पास power है. Parliament is empowered to provide by law. Parliament is empowered to provide by law residence as a ground for qualification. मतलब residence को as a ground for qualification लगा सकता है. Parliament can prescribe residence as a ground for qualification in the recruitment process of candidates in certain categories of employment under the state. मतलब क्या है कि जो Parliament can say or Parliament can impose and a qualification that you must possess the residence of this state for or in order to gain employment in that state. Okay, got it. Now let's move to Article 16 subclause 4. Article 16 subclause 4. Article 16 subclause 4 क्या बोलता है कि Article 16 subclause 4 says that it gives to reservation policy. ठीक है, reservation policy. So it says that state can make special provision. जो state होगा, state can make special provision. State can make special provision. State can make special provision. State can make special provision in the favor of backward classes. In the favor of backward classes. In case of in the favor of backward classes in case of public employment. ठीक है, in case of public employment. In case of public employment, if when state can make special provision when the said classes of citizens, when the backward classes of citizens are not adequately represented, when not adequately represented in service under the state, not adequately represented, okay. Now let us move to the next article, Article 16 subclause 5. Article 16 subclause 5. Article 16 subclause 5 क्या बोलता है? It empowers the state just like in Article 16 subclause 5 where Parliament was empowered to impose residence. So in Article 16 subclause 5 state is empowered to prescribe religion. यहाँ पे religion as a ground for qualification, religion को as a ground for qualification रखा जा सकता है in recruitment of candidates in certain categories of employment under the state. For example, you must have seen that whenever vacancy comes for religious teacher, it has been it's highlighted that the person should belong to that religion or this religion particularly. Okay, so Article 16 subclause 5, Article 16 subclause 6, it came with 103rd Amendment Act, 103rd Amendment Act, and is for EWS quota. You must be knowing it. Now let us move to next article, Article 17. Article 17. Article 17. Article 17 abolishes untouchability. Untouchability. Untouchability abolishes. Untouchability abolishes in any form and all form. The only article in the Constitution, the only article in the Constitution, the only article in the Constitution which is in absolute term, which is in absolute term, which is in absolute term. Article 17 is only given in its absolute term. Okay, that is untouchability in its all form is prohibited. Okay. Now what is untouchability? What is untouchability? The word untouchability has neither been defined by the Constitution nor the Parliament, but judiciary has defined it. Judiciary ने इसको define किया है as a social practice, as a social practice, as a social practice, as a social practice among Hindus, among Hindus, where a person solely or mainly on the basis of his birth is looked down and discriminated, discriminated. Now let us move to next article, Article 18. Article 18. Article 18 prohibits the state. It prohibits the state from conferring any title. State cannot give any title except in the form of military or academic distinction. Military or academic distinction. ठीक है. Article 18 prohibits the state from conferring any title except in the form of military and academic distinction. Okay. Now let us talk about Padma Awards. ठीक है. National Awards और Padma Awards. National Awards. As per Supreme Court, national awards are not a violation of right to equality. Not a violation of right to equality, because right to does not mandate that merit should not be recognized. Right to equality का ये मतलब बिल्कुल नहीं है कि merit को recognize न किया जाए. Merit should not be recognized. Merit should not be recognized. Merit should not be recognized. The person who receive national awards or Padma awards is not allowed to use it either suffix or prefix with their name. ठीक है, either suffix or prefix with their name. अगर मेरे को नेशनल अवार्ड्स पद्मा अवार्ड्स मिल रहे हैं तो मैं अपने ना नाम के आगे और ना नाम के पीछे उन टाइटल को जोड़ सकता हूं. ओके, सो यू मस्ट हैव गॉट टिल हेयर. सोने